What's up, everybody? Welcome to the Homie Hangout, where we help others move in excellence. And today I want to talk about 22 laws that go into effect in the state of California as of January 1st, 2022. And these are mostly laws that have to do with folks that have been engaged with the punishment system in the state of California. There's a couple other, laws in there as well. Before I get into that, if you haven't been to the channel before, you haven't looked around, I encourage you to do so. I spent a large part of my life in the streets and in prison, and so that's reflected in some of the content. But I've also spent the better part of the last 16 years since I paroled from the SHU program, trying to help advance a culture of healing, transformation, community, right? So that's also reflected. There's stuff on legal things, gang issues, prison, of course, relationships, addiction, faith, mental health. The list goes on. Interviews with people. So check it out. If it's something you're into, hit the subscribe button, the little bell notifications next to it so you can know when I post something again. So with that said, let's get into it. This is in no particular order. And like I said, 22 laws that go into effect in California as of January 1st, 2022. SB 73, no mandatory minimums for nonviolent drug offenses. Pretty self-explanatory. Those are gone. So judges are not obligated to go by these arbitrary sentences. They could take a lot of different factors into consideration. That's for nonviolent drug offenses. AB 1228, those violating probation get OR'd, released on your own recognizance, unless the judge says that you're a particular threat to public safety. And the burden for that is pretty high. It's not like before where everybody's a threat to public safety. Law enforcement still sees things that way. But a lot of these reform laws are putting a burden on the state to make a case of why this person is such an exception to a normal case. The other exception is a flash day 10 incarceration, flash 10-day incarceration. So if you're on probation for a dope case, if you got Prop 36 or something like that, you're subject to a flash 10-day incarceration for any kind of little violation. You can still get that. AB 1475, police cannot release your booking photos on social media if you're arrested for a nonviolent crime, unless that person was not caught and a judge finds that there's some legitimate law enforcement interest in putting their picture out there. But like if you get arrested, or even if you just get cited, and a lot of times then your mugshot goes up, especially with, Facebook and social media, cops will post the pictures of all or most of the people that they've arrested, for people to see. And so police can't do that anymore. Again, unless a judge says that there's some kind of a legitimate interest, which would be that you're on the run. Photos are removed after 14 days, no matter whether you have a nonviolent or a violent offense. If your record is sealed, if your conviction is dismissed, if you're found not guilty or you're not charged or, anything like that, right? And that's retroactive. So if you have mugshots up from the past or you have booking photos up from the past, you can get at those departments and tell them, hey, man, take it down. And so nonviolent offenses, they must be removed after 14 days, no matter what, no matter the consequence, right? SB 2, the state can decertify cops for serious misconduct, which means they cannot get another job in policing other places. Historically, a cop can get fired by a department, but they're still a cop. And so they can go to another department and get hired. In this, we know with this law, the state licensing agency, basically the state certification board, can decertify a cop. In other words, they're no longer a law enforcement officer. And so they can't go somewhere else and become a cop, either in the state of California or outside the state of California. Now, that doesn't necessarily mean that a cop is always going to get decertified just because they get fired, but it does open up the door for that possibility. SB 416, literacy programs. So every prison in the state of California needs to have as a priority getting everybody that's doing time up to a 9th grade reading level. Then they need to be, as a priority, get them a GED or a high school diploma. All prisons in the state of California have to offer community college classes, and they need to prioritize face-to-face classes, right? And also those classes, those community college classes, must be free of charge from every angle. So free tuition, books, the whole 9 yards. And also, if you're a student, be it in the ninth grade program or the GD program or the college program, then that counts as you having a full-time job in terms of getting like your A1A status, or, for people that are incarcerated, their privilege, quote unquote, status is based in part on employment. Do you have a job behind the wall, or are you going to school? And so taking these community college classes, even if you're not actually going to a separate part of the prison or whatever, it counts as a full-time job. So you would have full privileges. AB 333. I'm not going to spend a lot of time here on that. I did a video months back about that in detail and describe the law in detail and describe the application in detail. I will link to it in the video so you can go and check that out. But basically it means one of the big things is a gang enhancement. If you get caught for a case, so I'm working on a case, for example, in a county in California where an individual being charged with murder, but they also have a gang enhancement. So if this person goes to trial, they need to go through the trial, and the DA has to prove that they're guilty of the murder without introducing the gang element, right? And if they get found guilty of the murder at trial, then there's a separate trial in which the gang stuff is introduced, and the DA can try to make the case that the murder that they were just convicted of was in fact done at the direction of or for the benefit of a street gang, blah, blah, blah. So that's huge, right? Because that puts a lot of burden on the DA's office. As we know, as folks that follow the system, that have been in the system knows, once you introduce gang, it is unduly prejudicial. It taints the whole case, right? Where jurors are inclined to find you guilty of something, even if they're not sure beyond a reasonable doubt, because of that gang piece, right? You're scary now, you're a monster, they don't want you in the community. When you take away that gang piece, then the thought and the hope is you'll get a more honest, fair shake. And the DA will actually have to prove their case instead of just smut you up. And also, they're going to have to put resources into that gang trial. And so that costs money, that takes time. So anyways, that's the biggest part of AB 333. It is not retroactive. It goes into effect. It went into effect January 1st of this year. However, if you were arrested prior and you haven't gone through your prelim or any of that kind of stuff, then this applies, because you're not really going through the court process until after January 1st. I've worked on some cases. I work as a gang expert for defense attorneys around the country. And I'm working on some cases that got continuances last year until this year, just for the purpose of trying to see if this law applies. So anyways, like I said, I did a whole nother video on it. I'm not going to take a lot of time here, but for those with gang charges, it's probably the biggest legislation of the year. SB 483, no more mandatory 1 year prison prior sentences, right? And then there's certain drug crimes that used to be a 3-year enhancement if you had priors. So this applies also to people that pled out, which is important, right? So a lot of times when they make laws, the laws don't apply to people who took a plea. They only apply to people that went to trial and got found guilty. This applies to everybody. And so if you caught a case and you got 3 extra years because you had 3 prior prison sentences or county jail sentences or whatever, then this applies. And what happens is you petition the court. You have until March of 2022 if you're only doing enhancement time right now. What that means is, say you get 5 years for a crime, and then you get 2 years in enhancements for prison priors, 2 1-year prison priors. So you're doing 7 years, right? And I'm not going to factor in good time, just to keep it simple. Those first 5 years, you're doing that underlying offense. The last 2 years, you're serving your enhancement time. So if that's what applies to you, then you have until March of 2022 to appeal. You petition the court that sentenced you and say, hey, I'm on enhancement time. And they have to resentence you by October of this year. If you're not on the enhancement time, in that same scenario, if you're only on like year 3, so you're not done with your commitment time, then you still appeal, right? And you have until like July of this year to appeal. and then you're guaranteed to be resentenced by December of next year. The court can deny early release if somebody is deemed some type of excessive danger. But again, the burden is a lot higher now than it used to be, and you're entitled to court-appointed representation at that hearing to defend against the idea that you should be the exception because you're some particular danger. AB 69, you cannot be charged fees due to being arrested and booked anymore. A lot of us know what it's like, man. You get fees for booking photographs, you get fees for transportation, sometimes you get fees for the days you're incarcerated, and there's fees for house arrest and fees for this and fees for that. And so you could still owe restitution, which is different. But all those little booking fees, and you have to pay those fees whether you're convicted or not, even if they drop the charges, right? So now you don't get those. The county, they can't charge that. SB 56, before you get sentenced to an upper term. So for those that aren't familiar, there's an upper, a mid, and a lower. And so when you commit an offense, there's a guideline of upper is the 7, mid is the 5, low is the 3. And if you're a first offender and you have no priors, and you have this stellar community record and you just got caught on a fluke, then you might get the 3. If you've been in a little bit of trouble, but this is a different kind of trouble and blah, 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 you might get the mid. If this is your pattern and you're doing life on the installment plan, then you're going to get the high. So they use that, though. There's a big discrepancy in who they use that against, of course. So now, before you get sentenced to that upper term, either you have to just stipulate, which means basically, I agree and I'm not going to argue. So you can stipulate to these aggravating factors, and then it's a non-issue, right? But if you don't, then you get a separate trial on what those aggravating factors are. So whatever the DA's argument is for why you should get the upper term of a sentence, he has to prove that, or she has to prove that at a trial beyond a reasonable doubt. Again, after you've been convicted of whatever the underlying offense is. So you get busted for a robbery, but they're trying to give you the maximum. You get another trial to argue, what are these factors that you say means I should get this upper sentence? And again, similar to AB 333, that puts a lot more burden on the DA's office. And so I think they'll be a little bit more reserved about going for that upper sentence. And, obviously it's an encouragement to people to fight their cases, man. Know the law and fight your cases. I'm not condoning crime. I'm not suggesting anything of the sort, but you have rights in this country, and exercise those rights. So SB 354, this is a little bit different, but before, if parents lost custody of their child, right, either temporary or permanent, that kid could not go into the care of a blood relative if that blood relative has a prior conviction, right? And then there's also this bar that I won't get into the details of, but there's this standard for, do you have the economic resources to take care of the child, right? So, and the county applies that. So this law, SB 354, says that a prior conviction does not in itself prevent you from getting temporary custody of blood relative kids. Now, if your prior conviction is for unmentionable stuff involving children, then obviously that's different, right? As it should be. But if it's, a dope case, or even if it's violence, but it's not violence that you could look at and say, well, based on this past violence, this child specifically could reasonably be in danger. So that's helpful. And then also on the money end, the burden is on the county and the state to connect you with the financial resources that you need in order to embrace this new responsibility of a child. And so that's good. And it's particularly good, keeping kids and families. This will have a real impact on the indigenous population. Since the beginning of colonization, there's been a pattern of stripping children away from their parents for a variety of reasons, and then putting them in another family in which their native culture and beliefs is not going to be represented or encouraged. So That's another one. AB 1540, juvenile sentenced to life without the possibility of parole can apply for resentencing. There's a bunch of factors that the court has to look at in determining if you should be resentenced. Was it under the old felony murder rule, right? Meaning you didn't actually do it, but you were involved in a crime that counts as a felony and somebody died. Was your co-defendant an adult? What is your prior history as a juvenile? Do you have violence? Can you show proof that you've done self-help stuff while you've been incarcerated, rehab stuff? Did you have mental health issues at the time? Do you have positive ties with your community, right? Have you gone 5 years without violence as a juvenile since you've been incarcerated? And so again, the burden is on the DA. The default assumption is you should be resentenced. If the DA doesn't want you to be resentenced, they have to make the argument as to why. And that is obviously retroactive. SB 81, the court can strike a penalty for an enhancement and dismiss it if it furthers the cause of justice. What are the factors that further the cause of justice? Did it lead to 20 plus years on your sentence? Did this enhancement, advance a racial disparity within the system? Did you have multiple enhancements? Was mental illness an issue? Is there prior trauma? Was it a nonviolent offense? How were you as a juvenile? How old was the conviction? On and on and on. So what that means is you can still get charged with an enhancement. The judge can say, okay, the enhancement stands, but the additional time that normally goes along with that enhancement does not apply, right? Or they can just say the enhancement is thrown out the window, period. So for example, say you have, like when I caught my attempted murder, right? Which I wound up, pleading to. But initially what I was charged with was a whole host of crimes and a whole host of enhancements, right? And stuff about fire and discharge in city limits and county limits and inciting a riot, but then also gang enhancements, gun enhancements, all sorts of things. So the judge can look and say, pick an enhancement. The penalty will apply for that enhancement, but the rest of these enhancements can stay, but we're not going to keep adding in terms of the sentence. And so that's, in my opinion, that's another good one. Also with firearm enhancements, which are very, common. If the gun wasn't actually used in the crime, you cannot get a fire enhancement. So for example, if I have a gun and I rob you, but I don't show you the gun, I don't pull the gun on you, I don't, nothing. I'll just walk up and say, give me your money, and you get scared and you give it to me. And I run and I get popped around the corner by the cops and they search me and they find a gun in my backpack. There's no gun enhancement for that because I didn't use the gun in that crime. You also don't get a firearm enhancement if the gun doesn't work. If the gun is malfunctioning, if the gun is a non-usable gun, there's no firing pin or whatever, then there's no gun enhancement because even if you did brandish it or whatever, it was not possible for you to use that firearm in the way that firearms are intended to be used if it doesn't work. And so again, that's AB 80 or SB 81. AB 124, victim of domestic sexual violence, you can use that as a defense in a nonviolent crime. And a big one that it applies to is perjury, and this is retroactive. So if you have convictions, you can go back and get those convictions off your record. But a lot of times they would get people and because of their fear, right? Predominantly it applies to women, but because they're victims of a domestic violence or victims of sexual violence or intimate partner violence or whatever, they're intimidated, they're scared. Sometimes they are forced to lie on the stand. Sometimes they lie on the stand out of fear. And that's not uncommon for defendants or witnesses in tons of different cases. But they're making an exception for these folks and saying, if you perjure yourself, because that's a threat the DA uses, I'm gonna get you because perjury, this and that. And so now they're in a rock and a hard place. Now that perjury doesn't stand. That's a defense again. Now you still got to go through the process, but it's a defense at least. You can make the argument, yes, I lied on the stand, but this is why. And that already applied to to sex trafficking cases, right? People that were picked up off sex trafficking or were victims of it, I mean. And now they've just extended it to also include this group of people. AB 57, hate crimes. I did a video on Asians and being targeted in hate crimes. I also broke it down in a video that I did covering a range of laws earlier this year. Some of these are included, a lot of them aren't. I will link to those videos as well. But the main part of this is if you target the same group of people, then you could be charged with a hate crime. So for example, if you rob a lot of people that you think at least are undocumented workers, right? And maybe some of them are, maybe some of them aren't, but you think that they are, right? Because they're street vendors or because they work in a field or a cannery. And so you go there and rob people all the time. That can be a hate crime. If like the case in the Bay Area, if your targets are Asian, right? It doesn't, they don't have to prove that you hate Asian people, right? They just have to prove that your victims are all Asian. So your reason for robbing them, they're low hanging fruit or it's just opportunistic or whatever, doesn't matter. So the hate crime law is really expanded to include a lot of different stuff. Also, if you go after people that are perceived to have a disability, and you don't go after other people perceived to have a different disability, then that could be a hate crime, right? So if you rob homeless drunks, that could be perceived as a disability because they have, substance use disorder and mental health issues, let's say, but you don't rob people in wheelchairs. That could be a hate crime. And so we'll see how that actually gets applied, but historically speaking, the punitive system takes advantage of any opportunity to increase penalties for crimes. And so I would expect that to come up. SB 224, and this is where we get off some of the legal stuff, some of the, punitive system stuff. SB 224, mental health needs to be a component in any health education classes for middle and high school students. AB 357, all schools, Cal State colleges, community colleges, UCs, they need to have free time of the month, shall we say, resources in their bathrooms, right? Any bathrooms that serve females from 6th grade and up. They need to be in all women's bathrooms. They need to be in all gender neutral bathrooms and at least one men's bathroom, which I found interesting. But moving on, SB 360, AB 570. So parents can get on their adult kids' health insurance as long as it's purchased. And so if your health insurance is looking bad, but you have a grown child who's an adult and they have a great insurance plan, they can put you on their insurance. And that's the first in the nation. California is the first in the country to do that. There's been a big push to be able to keep kids on their parents' health insurance plan, even as the kids reach adulthood. But this is the first time it's being looked at from the opposite perspective. AB 89, minimum age to become a cop is now 21, not 18. There was actually a push to make it 26, and that got shut down. And it has to do with the age at which the brain is fully developed. So take that for what it is. AB 701, warehouse retailers. So if people that work for Amazon and the Valley especially has a lot of warehouse stuff. So you can't be fired for missing quotas that would cause you to miss out on breaks or bathroom breaks or whatever, right? You also cannot get in trouble for following actual health and safety laws, which employers will do. They will tell you, nah, just work around it. Let's cut some corners, right? And you would get in trouble if you don't cut those corners. But cutting those corners is against, different laws, OSHA laws, FDA laws, or whatever. Now you can't get in trouble for sticking to those. And that's important because a lot of people get hurt from breaking laws at work because their employers put that pressure on them. And so they do cut corners, and then people wind up getting hurt and they have no real recourse for it, because when they're hurt and they want some benefits, they're told, hey man, you broke the rules, it's on you. And so and then also warehouse workers can sue if there's quotas that are put that make the work environment unsafe, or if they feel like they're being retaliated against for calling the employer out on proper procedures, then they can sue that employer, which I didn't know that they couldn't before. But anyways, AB 1276. This is just kind of an odd one, but takeout orders, including drive-thrus, will only give you condiments and utensils if you ask. And so they'll still give them to you, but instead of just automatically throwing them in the bag, you have to ask for them. And so keep that in mind. AB 1084, and this has gotten some attention, and it's odd because it applies, it goes into effect now, but it's not enforced for like 2 years. But retailers that have over 500 employees have to present certain products for children, right? Toothpaste, toys, that kind of stuff, in a gender neutral way. It does not include clothes, and there still can be a boy section and a girl section. There just needs to also be a neutral section that has kind of a balance of stuff from the boy side and the girl side sort of thrown together. That does not get enforced until 2024, but it technically went into effect on January of this year. So that's it. Those are 22 laws for 2022. If there's any laws that I didn't cover that you want some feedback on, obviously feel free to leave it in the comments. I will do my best. If there's other states that you want me to kind of take a look at laws over there, I can do that. I live in California. A lot of my familiarity is based around California, but also do and know stuff about other states, to some degree. And I generally have people in almost every state in the country that I can reach out to and talk to. So leave that in the comments, man, and let me know where you guys are from. I'm always interested to see, where people are coming from in a hangout. And so up here, some playlists and some videos you might want to check out. I'm the homie Joshua. Some people call me Rascal. This is the Homie Hangout, where we help others move in excellence and help ourselves at the same time. Have a great one, man, and welcome to the new year.